So let me talk about mediation and how can I be prepared for mediation. So hopefully everybody understands what mediation is. So mediation is a chance for you and the other attorney to resolve the case on your own terms. And in my mind, resolving the case on your terms is the best way because, as many of you probably know, when you leave it to the judge, it's a gamble. You do not know what the judge is going to do. The judge may not understand your background, your history, the child's particular needs. There's a lot that the judge may not understand. And the judge is only making decisions based on what he or she is hearing in an hour's time or 2 hours time or 3 hours time. I have cases where parties have been married for years and years, and I have to present their whole life in an hour or two. And it's extremely stressful for me, but more than that, it's stressful for the client. But it's like going to Vegas. Going to trial is like going to Vegas. As a matter of fact, I'm writing a book on that right now, and I'll keep you posted on the book. So mediation is an opportunity to resolve the case on your terms. When you're in mediation, you're meeting with a third party who has training in helping people resolve their cases. There's a couple different types of mediation. There's private mediation and there's court-ordered mediation. So private mediation is where the parties hire an attorney or a mediator out in the community to help them resolve the dispute. And they have to pay the mediator's fees and they have to pay for attorney's fees if attorney's fees are involved. I love private mediation when clients can afford it because I have really good results at private mediation. Court-ordered mediation is when the judge appoints somebody associated with the court to help resolve the case. So getting to how do you prepare for mediation? The number one thing that I want to do when I'm prepared for mediation is knowing that I have all the information I need from the other side so my client can make an informed and a voluntary and a knowing decision. So I don't know if any of you have heard me talk about requests for production or discovery requests. So there's certain things that you can send to the other side saying, essentially, these are the questions that I have, and I want you to answer these questions for me so I am fully informed about what your position is. So often before I go to mediation, I send these discovery requests out. I want to have the other side's discovery requests and answers back to me when I go to mediation. I want to have all documents. So if this is a divorce case, I want to have all information about credit card debt, about property values, like appraisals of homes if that's necessary. I want all information about criminal convictions if kids are an issue. I want information about medical issues if there's a spousal maintenance issue. I want as much information as possible walking into mediation. If I don't have that information, then my client's not going to be able to make a decision based on full facts. By the same token, if I'm wanting this information, I need to make sure that I disclose it to the other side. I have to provide them with whatever they're asking for from my client. So there are rules of disclosure. There's two big D's in the law. There's disclosure and there's discovery. Disclosure are things that wherever you are, whatever jurisdiction you're in, you're required to give to the other side. So this might be, for example, one big example is a financial affidavit. There might be other things that you're required to give according to the rules. So you need to check your rules and find out what mandatory disclosure is. So that's the first D. Disclosure is your affirmative duty to give something to the other side. Now, discovery is when you're requesting something from the other side in an attempt to discover, or the other side is sending you discovery requests in an attempt to discover. So there are timelines to respond to discovery requests, and there are consequences if you don't respond. So prior to mediation, all your disclosure must be done and all of your discovery must be done if you want to be fully prepared. The next thing that I do to get prepared for mediation is to outline what my client's positions are. So I go through and I outline whatever, I make a list of every single issue in the case. So if it's child custody, parenting time, child support, spousal maintenance, the division of property, the division of assets. And then I break it down even further. I ask myself and I ask my client, well, what does my client want for custody? What is the exact parenting schedule that they want? What is, the holiday schedule they want? What are their child support proposals? What do they want in terms of dividing up debt and property and assets? And make an outline of that. That way I know what my client wants. Going into mediation, you need to understand that you're probably not going to walk away with everything that you're requesting. And that's because you're going to have to compromise. And that's hard. It's hard for everybody. It's hard for me. But, you have to weigh it. Am I going to compromise or am I going to go to trial? Because if you don't compromise, then you're going to end up in trial. You're going to end up, if you have an attorney, spending a lot of money and a lot of time to end up in trial where you don't know what's going to happen. So whatever your positions are, be willing to settle for less. And, you may be surprised. You may get exactly what you're asking for. Sometimes that does happen. But you have to have clarity around what you're entitled to under the law and what you're requesting.